So a report released this month by Governing magazine shows that in the last fiscal year, 9,500 lawsuits were filed against the city of New York. And the city ultimately had to pay out $720 million in judgments and claims. That adds up to $84 per person in the city. And it's more than combined budgets of the Parks and Recreation Department and the Department of Buildings. I mean, let's face it, it's almost $1 billion. The Lawsuit Reform Alliance says something has got to be done. Tom Stebbins is the executive director of the group. Welcome. How are you?
I'm well. Great to be with you, Susan.
So the article states that the city happens to be in a state with several laws on the books that can drive up the city's legal costs. So when you read that headline in Governing magazine, in which you were quoted in the article, what went through your mind?
That it's an astronomical figure, that money could be spent on so many other things. Whether you're a Republican or a Democrat, that money could be spent on infrastructure, could be spent on schools, it could be spent on lowering taxes. It's a huge figure, and I think folks ought to be outraged because more importantly than it's more than the Department of Parks and those different departments, it's also higher than the next 19 cities combined. And those are all combined. So we're talking it's larger than Los Angeles, Chicago, Miami, all the biggest cities in the country. So it's impossible to look at this data and say, well, New Yorkers are just more litigious, or we just have a more litigious culture. This figure is so high that we understand and we see that something else is going on. And we feel that it really is the state laws here in the state capitol that are driving these costs.
So state laws like?
Well, one of the ones mentioned in the report is something we've talked about on this show, which is the scaffold law, a law that applies absolute liability if there's an injury. So folks get workers' comp, but then they get a general liability claim on top of that, and that claim is almost automatic under this quote-unquote scaffold law. I don't know how it got that name. It doesn't necessarily have anything to do with
scaffolding. It's more like the gravity law. But
yeah.
But the two most expensive settlement categories don't have to do with the scaffold law. One has to do with police issues, and the other has to do with accidents caused by aging infrastructure, which you mentioned. There are ways you could spend $1 billion, like upgrading infrastructure. You said that
right,
before.
And accidents caused by aging infrastructure are often scaffold law claims.
Are they?
Absolutely.
I thought that it was only people involved in construction.
Right, and infrastructure construction would be part of that. And so we've seen that with a study that was done by the University of Albany that showed that statewide that particular law costs about $785 million, and the city is obviously a huge portion of that.
So what is New York doing to curb these lawsuits?
Not much. I mean, that's the real problem here. You can imagine if a corporation was that provided municipal services, was charging New York City more than they're charging the next 19 cities combined, there would be absolute outrage. The New York legislators would jump at the chance to fix it. And yet here we have the same problem with our legal system, and we don't hear a lot of activity here in the halls of Albany. And I think a big reason for that is because of the influence of the New York State Trial Lawyers Association. They are, Governor Cuomo called them the most powerful political force in Albany. There's a report in the New York Post today about their chief lobbyist and how he has so many more contracts now that Speaker Heastie has ascended to the speakership. So they're a huge constituency, and they have undue influence in Albany. I mean,
what is the link between the lobbyist and Heastie?
So they were college roommates together. He was a former spokesperson. He's also a paid consultant. So he's paid by Heastie's campaign, and he also is paid by the New York State trial lawyers, among many others. And he used to be just the trial lawyers lobbyist. And now, since Heastie has ascended to the speakership, he has a lot more clients, as you can imagine.
All right, so there are some things that the city is doing. Part of the article was devoted to this concept of Claimsstat, which is a program that was instituted by, I think, the city controller, Scott
Correct.
Stringer.
Yep.
And basically, well, maybe you can explain what Claimsstat is and if it's effective?
So Claimsstat identifies where the lawsuits are so that they can find, is there a particular park that is driving a lot of these lawsuits? So, for example, we know that skating parks, skateboard parks, drive a lot of municipal liability. And they shouldn't necessarily.
We could have figured that out without a study. But anyway.
Right. But they shouldn't, because what often happens is that these parks are trespassed in the evening and people get injured at night, even when the park is closed. And under New York law, even a trespasser has a valid claim, where in most other states, they would say, if we didn't expect you on the property, if the park was closed, you can't then sue us for your injuries. New York doesn't have such a law, and that's just one of the kinds of state laws that we need to lower these costs.
That seems like a no-brainer, you know?
Absolutely.
You can't sue us if we've told you that it's dangerous.
Right, and homeowners are also affected by this. So if somebody were to break into your property and injure themselves while they're breaking into your property,
they're burgling your home.
You're liable for their injuries. And that's an insane statute and something we really need to fix here in New York. But we can't, again, because the influence of the Trial Lawyers Association, who wants to sue on behalf of that burglar. And get their 33%, which is important.
Is it really 33%?
That's
or are you
generally
is that hyperbole? Or?
No. That's generally what a plaintiff's attorney will charge. A third is pretty standard for a plaintiff's attorney's contingency fee for when they win a lawsuit.
There's a quote in the article that I wanted to ask you about. It's from the president of the Public Risk Management Association, and this person says the acceptance of personal responsibility seems to be dying out somewhat. If we're in a culture that has shifted away from taking personal responsibility, what can we do about all this litigiousness?
Right. I mean, it seems like any accident is a lawsuit. There are no
somebody
accidents anymore.
Needs somebody to blame.
Right.
And it's going to be the municipality.
And it's never themselves. So if you're breaking into someone's home, it's not your fault, it's the home's fault. That's how crazy our laws have gotten. And, you know, we really need to fix that, because there needs to be some personal responsibility. We can't just sue deep pockets. And in this case, the city and our municipalities are the deepest pockets of all.
And, of course, those deep pockets are deep because of the taxpayers.
Right.
It's our money.
Absolutely. We're all paying for it.
Have you ever sat down with the Trial Lawyers Association, or are you guys just sort of, you know?
They don't like me very much,
No,
Susan.
I'm sure that they don't. I'm sure that they don't, and I'm sure that you don't like them either. But, you know, there is always compromise to be found somewhere.
Well, make no mistake. If somebody is injured through the fault of another, they should sue and they should collect. That's not what we're advocating for. We're advocating for balance in the law. So you don't have things like the scaffold law where you have an automatic claim, or you don't have burglars collecting millions because of an injury while in the commission of a crime. Those are the things that we're going for.
Do you have legislation that's like ready to go?
We have legislation on all of these issues, and we certainly want everybody to support them, because they're really common sense things. They're not saying, you know, you can't sue or you can only collect this much. That's not what we're going for. We're trying to enact common sense law that can lower these costs, because being higher than the next 19 cities is a major problem. It's an outrageous figure.
In the minute that we have left, the lowest total spenders of the 20 cities that Governing Magazine looked at were Fort Worth and Columbus, Ohio, whose total yearly costs were less than $3 million. Obviously, New York City is a lot larger, but what can we learn from a Fort Worth?
Well, we can learn about things like standards for experts, right? These states have standards for experts. So in New York, we don't have standards for experts. You can bring any wackadoodle into testify, and you also don't know who they are, which it makes it very hard to defend yourself if you're the city. We also have a joint and several issue where if you are 1% liable, you can pay 100% of the judgment. We need fair share liability so that if you're 1% liable, you pay 1% of the judgment. And that's how the city gets roped in so often. When somebody sues, they sue the municipality, they sue the Department of Transportation, they sue the Department of Schools, Department of Buildings, they sue everybody they possibly can, because if they can prove they're 1% liable, those people can pay 100% of the judgment. And in this case, it's us. We're paying that.
This article can be found in the latest issue of Governing Magazine. And even if you don't happen to get a subscription at your home, you can go online to Governing Magazine.
And you can find it at our website, lrany.org.
Tom Stebbins, Executive Director of the Lawsuit Reform Alliance of